I'm JD Hoover, your host of the Bold Today Show, where you, the inventor, entrepreneur, or business owner, get your daily dose of inspiration to make the world a better place. All right, well, part 3 of our 5-part series on patent licensing, diving deep into this area of law because it's important about keeping that goal in mind and making sure you understand what the vision is for moving your product into the market. So today I want to actually ask you the big question, right? I need you to make your mind up. Spend some time today thinking hard about whether you really want to build that business, right? Collect members, form a business entity, hire employees, independent contractors, build a supply chain, all these things that take an incredible amount of time and resources in building a business. Or are you going to think about being the technologist and just do innovation and let someone else do all the work of building that business and look to license? So there really are 2 separate paths. I want you to think really hard about this. And if you've got any difficulty based on what we've talked about, please follow up with us at our website, boldpatents.com, or just give us a call at 800-849-1913. So your bold challenge today is to put in the comments below which way you're going, license or business. All right, today we're looking specifically at license agreements, and within the clause, looking at how do we enforce payment terms. Yesterday we talked about royalty agreements and how you actually think about whether it's net sales or if it's gross receipts. Today we're talking about, okay, what if you've agreed, right? The contract is done and you know that the other party, the licensor, has received money on their end for your licensed product, but they're not paying, okay? It's not so funny, but this is a scenario that is quite real. And if in that contract you're not clear about how you're to get what your recourse is, that's a problem. So at the time of contracting, you need to be very clear about what happens under the contract if they don't pay, right? They don't perform. They don't pay the royalty, especially within the time frame given. What is the remedy for breach? So breaching a contract, much like any other contract, is state specific. And so your licensing attorney is going to want to make sure that they put in specific provisions that will bind the party that is signing the agreement. Without digging into state contract law too much, I want to focus our attention on what to think about in terms of the patent and what that means. And as soon as there is a breach in a license contract, there's big trouble, because now that licensor who had the rights to make, use, and sell your invention no longer does. And the party is actually immediately liable for infringement. So if they continue selling after the breach, they are literally directly infringing. And so immediately upon a breach, it's beholden, or it's in the best interest of the licensee to write a cease and desist letter clarifying the fact that the licensee has rights in that invention and that no longer does the licensor have the permission to use that invention for revenue, right? They have no longer the ability to make, use, sell, or import into the jurisdiction without your permission. Now, one way to avoid this is to take a security interest in the actual product. So if for example, before jumping to this breach, right, if there was an intermediate step after the licensor stops payment or doesn't pay on time, instead of the first step being breach, there could be a security interest given to the licensee. This is sort of similar to that upfront payment. Instead of having cash, you take stock or ownership interest in the company. And so what can happen over time if the licensor doesn't pay the royalty is that the licensee actually begins to own the company or own the entirety of that sales stream. So they own the potential for that down the road. And what's interesting is that this can come about at any point in the patent process, including in the application phase and of course in the issued phase. So for all of you out there that are following along, I know I've hit on some details here. You can license your patent application while it's still pending. All right, so don't miss that. It's pretty exciting, right? So just having it just filed. It hasn't even been approved yet. If there's enough interest in the market for your product and there's enough promise that it will actually get issued, you can market that. You can get a royalty payment, get real dollars for your invention even before it gets issued. Pretty exciting stuff. So if you have any questions about that, of course, anything at all about patent law, please get a hold of us. Our number is 800-849-1913. All information is on boldpatents.com. I'm your host, J.D. Hoovener of the Bold Today Show. Have a great day. Go big, go bold.